was heard on the change of venue issue. Oftentimes, counsel will stipulate to a voluntary transfer once it's pointed out. If it's not resolved at the TRO stage by way of a stipulation, then my practice is to set the motion for change of venue on the same day as the hearing for the preliminary injunction. And again, if I rule on the preliminary injunction and grant it, but feel that the case belongs in Ventura or San Diego or wherever else, I may still issue a preliminary injunction to remain in effect until it gets to the right county, with the understanding that review of that order can be sought in that court.
Now, before you start drafting your papers, you want to think about what you want to prove in there. And first and foremost, at the TRO stage, you want to prove that there's an emergency. You want to show the judge the emergency. And then secondly, you want to make a showing of as many as possible of the elements that Peters described: the irreparable injury, the probability of success on the merits, the inadequacy of the legal remedy, the public interest, and anything that you can show that will bring you within also the case law and the statute law and the particular right you're trying to wrong. Then you're going to start preparing your papers, which are going to be the complaint, the affidavits, the memorandum of points and authorities, the order, and the undertaking. And copies of samples of those are from pages 129 to 143 of your material. And briefly, I'm going to go through what those papers are. The first paper I start to draft is the application on the TRO and OSC. And the reason I do that is the order I'm trying to seek. So what I want to do is think very succinctly, what do I want to get out of this hearing? I don't want to end up wasting time on very lengthy points and authorities where I really don't need them at this stage in the proceeding, or a complaint that is 32 causes of action, when what I really want to do is stop a nuisance, as in this case. So in this case, I drafted an order, which you can see at page 129. And in that particular order, it's interesting because both the relief I'm seeking on the TRO and on the preliminary injunction are the same relief. That shouldn't be the case in every instance, and you really need to think, what do I need on an emergency basis? That's the TRO. And what do I need pending the trial on the lawsuit? That's the order to show cause for a preliminary injunction. And be sure that you say to yourself, is this relief really necessary to protect me at the TRO stage? Because the judge is going to say that to you, and the opposing counsel is going to say that. And what you want to do is you want to go into court with an order that you can support, that the court's going to look at and think is reasonable, and that if the haggling starts over the order, you're going to have something there that the judge, who has 20 matters to cover in the next 2 hours, is not going to have to sit there and draft out a new order, because the judge is not going to be very happy or sympathetic about that.
Along that line, for the benefit of those of you who are either new to the practice or don't have frequent occasion to seek injunctive relief, the form books aren't filled with misprints where they reprint the same language twice when they show to set it out separately for the TRO and the OSC. The reason you do it that way is that the court may deny your request for a TRO, but nevertheless issue an order to show cause and set it for hearing on a preliminary injunction. And the introductory language as to each is different, and so it does have to be set out twice. Otherwise, you're going to have the judge order you to go out in the courtroom or the hallway, sit down and interlineate it all by hand, and you'll have writer's cramp and a messy order.
Now, also, in drafting your order, you do want to see if you can draft it in a way where it's not just a form over substance, but where you really are seeking a prohibitory injunction. To the extent that you can, and you may want to seek alternative relief of a prohibitory and a mandatory injunction, the prohibitory will in itself stay in effect on appeal unless the court grants a stay. And there are instances where you can imagine that you could ask for a prohibitory injunction that really is a prohibitory injunction, and also ask for further relief in terms of a mandatory injunction. Obviously, if the court thinks they're really both mandatory injunctions, the court will treat them as mandatory injunctions. Next, you're going to draft the complaint. And remember, on the complaint, which is at page 149 of your papers, there's no cause of action for an injunction. That's part of the relief that you're going to seek as part of another cause of action. And in this case, we're suing for declaratory relief and a nuisance. And as part of the nuisance, we're asking the court for an injunction. You have to decide, is the complaint going to serve as your factual basis for the TRO. Under the statute, it can, but I don't recommend that it does so. Remember, in a complaint, you're going to be pleading conclusions of law. You're not going to be, hopefully, pleading your evidentiary facts. And the complaint ultimately may be insufficient to support your TRO. If you are going to use the complaint to support the TRO, it must be verified. And remember that an attorney cannot verify the complaint. It has to be verified by the client unless the attorney happens to have personal knowledge, which is the rarity.
And then when he verifies that he's waiving the attorney-client privilege, so it's really never a good idea.
Now, in drafting the complaint, keep in mind that you want to go through the essential allegations that need to be in there. You want to show the plaintiff's status, the defendant's status in relation, all the venue provisions, the facts that state the cause of action for relief. The specific acts you want enjoined should also be in the complaint. And you want to draft a complaint that is hopefully relatively simple, because the other thing you'd like to avoid is a demur. Now, a demur obviously ordinarily can't be heard if you have your OSC set in 15 days. However, what often happens is everyone asks for expedited discovery. The hearing on the preliminary injunction may be put off for about 30 days. The defendant or the responding party has plenty of time to file the demur, and then instead of being the party on the offense, you're the party on the defense. You're fighting a motion to change venue, and you're fighting a demur. You're trying to respond to the other side's papers on your injunction, and it can be quite a mess. So I think creative pleading is not something that I would strongly recommend at the injunction stage. Get a complaint on file that you can support, and you're not going to have a fight to support. Then next, you're going to want to prepare your memorandum of points and authorities. And in preparing the memorandum of points and authorities, you do want to very carefully consider who your judge is. In LA, you're going to go before judges who hear injunctions on a day-in, day-out basis. They're familiar with the case law. You can spend a little bit of time familiarizing themselves with, what is irreparable injury. But if you're going before a judge who, in another court, in another jurisdiction, who maybe has a whole variety of calendars that that judge is hearing, and injunctions are not the primary focus, you have to gear your papers to that. You may want to spend much more significant time explaining the standards to the judge, so figure out who your judge is. Also, be certain that you follow all of the rules. It's the table of contents, summary of argument, length of pages, because remember, in order to file papers that are in excess, for instance, in LA County, the page limitation is for 15 pages, or wherever you're going to be filing, most of the jurisdictions now are having page limitations. If your page limitation, if you exceed the page limitation and you haven't drafted that application that we all, probably everyone in here drafts continually, which the judges hope we will be drafting fewer of, an application to extend the page limitation, and you don't have that with you, you may find that the court says, I'm not going to be able to read past these first 20 pages or 15 pages. The judge in San Diego County said to us that he's only going to read up to the 20th page. I guess that's their page limitation if you don't have your ex parte application. So be sure that you know what the page limitations are and that you follow them. And the two defects are repeating case law that the judge already knows and too lengthy points and authorities. Be sure your points and authorities succinctly bring together your arguments, the declarations, and the case law, but you don't have to put in an opus, because the judges, remember, are hearing those 20 cases in that 2-hour period, and it's pretty tough.
Oh, wait a second. I don't know anybody hearing 20 cases in a 2-hour period on TROs. I think I'd jump out the window if I had to do that. Not on my worst day has it been that bad. But it is up to half a dozen or 8 in the 2 writs and receivers departments in LA. And some of them are more complex than others. The key thing to remember is keep it simple. And if you just remember the phrase KISS, which certain judges have posted on the wall, which is keep it simple, stupid, you'll really be home free. Tell it simply the way you would to a 10-year-old kid. Convey the message in the opening paragraph of your memo, in the opening paragraph of the declaration, in the opening paragraph of the complaint, because you don't know which one the judge is going to pick up first. And you've got to get the point across so that somebody is immediately grabbed with your side of the story. You have to treat it as though you were talking to a lay jury. And even though the judge may have some sophistication, with the standards that apply,